We've reached episode 25 of the Borman Lawyers Court Reports show, where we appeared at Waverley Local Court in the eastern suburbs of Sydney on a middle-range drink driving offence, coupled with a high-range speeding offence.
Yeah. Honestly, I think that 24/7 an understatement to my day-to-day. If ain't no way, then I'ma make a way. They say it ain't no way. I ain't never listened, kept them at the distance. This is for the ones who ain't afraid. And this is more than some paper chase. I wonder who else could say the same.
Hi, Josh Borman here, just from Borman Lawyers, just standing outside here in this cold and wet Sydney day out the front of Waverley Local Court, where I've just appeared on a quite a serious traffic matter involving a middle-range drink driving offence where the blood alcohol reading was 0.126. But that was also coupled with a high-range speeding offence where police allege on an estimate that my client was doing up to 68 kilometres over the limit, so 168 in a 100 kilometre zone. So that was obviously viewed as a serious aggravating feature to the drink driving offence. What was also made my client's matter far more serious was the fact that this particular offence of drink driving was a second drink driving offence that my client has received on his record. He has one about 5.5 years ago. So in preparation of this matter, we've got our client to go along and do a traffic offenders program, a fully approved course, where he successfully completed that. He got a workbook, a completion certificate. We were able to tender that today as proof of his participation in that course. We also got our client to go along and get some drug and alcohol counselling from his psychologist. We also got a report from his psychologist confirming the treatment sessions that he has already done, and a treatment plan that she put in place for him to continue with drug and alcohol counselling and treatment going forward into the future. We also got a letter of confirmation from our client's old employer, informing the court that he had been terminated from his position due to a loss of licence. And we also got another letter of support from a friend of our client's, and also a letter of apology from our client that we submitted to the court, which went into some of the issues and circumstances of how the offence came about. Basically, in relation to the events that led up to the offence, our client was over at his girlfriend's place with his girlfriend. He had been drinking all afternoon, and that evening he had ended up getting into quite a nasty verbal argument with his girlfriend, and made a decision to leave the residence, but an even more foolish decision to get into his vehicle to drive home. Police allege that he was speeding along the M5 at high speed, driving erratically, moving in and out of lanes, flashing his lights at slower cars. So it was very unacceptable sort of behaviour to carry out on the roads, especially for a person who had a blood alcohol reading of 0.126 in the middle range category. So it was quite a serious situation. We did plead with the court to have regard to the fact that it has affected his ability to earn an income. He lost his job. He has engaged with a psychologist to address alcohol issues. It's the first time he completed the traffic offenders program. His overall attitude and remorse towards the offence. It was worth noting that once he did see the police flashing lights, he immediately pulled over to the side of the road, cooperated and complied with all of the police directions. So there was no indication that a police pursuit was involved in this particular matter, which would have certainly increased the severity of the offence in itself. But still, it was a serious offence. But we were able to persuade the magistrate to reduce the period of disqualification from 12 months to 6 months, and backdate that 6 months to the date of the offence when he first lost his licence. And that was for the drink driving offence. He was also put on a Section 9 good behaviour bond for a period of 12 months. A condition of that bond is that he needs to continue with his treatment with his current clinical psychologist in relation to his alcohol treatment. In relation to the high-range speeding offence, he also received a period of 6 months, which was to be backdated, and he also received a $1,000 fine for that particular high-range speeding offence. The maximum fine for high-range speeding is $2,200. However, that was reduced by more than half. So that was the situation my client is currently in. It is debatable and whether the 6 months will be run concurrently or on top of each other. My view is that they will be run at the same time. That was also the view of the magistrate of the court. However, the Road Transport Department, or the RMS, do often have the ability to override whether the disqualification periods are run at the same time or on top of each other. But from my understanding of how the law reads is that the 6 months for each of the offences will commence from the date of conviction, which is today. So the 6 months for the drink drive and the 6 months for the high range speeding should run at the same time together, which would ultimately mean that our client would be able to recommence driving towards the end of the year, around October, November. So that was another offence that we've just appeared on here at Waverley Local Court in the eastern suburbs of Sydney. It was a little bit more serious than your average drink drive offence. It was aggravated to a significant degree by the high range speeding, his erratic driving, and the fact that it wasn't his first offence. So overall, our client was very happy with the outcome. We were happy with how the case came together. The magistrate was receptive to what we had to say, and for that reason, our client came out with a far better result compared to if he had have just gone in and represented himself, as was the case on his first occasion over 5 years ago. So if you found yourself in a situation where you've been charged with a drink driving, drug driving, or serious traffic offence, either in New South Wales or even Queensland, feel free to contact us, or me, Josh Borman at Borman Lawyers, on 1300 941 900, or alternatively go along to our website, which should probably be your first port of call, which is Borman Lawyers, BOORMAN, lawyers.com.au. There's plenty of information there on traffic laws and offences and penalties, and you can read up, make yourself familiar with the situation you might be in, and then you can give me a call on 1300 941 900 to talk a little bit more about your matter and how we can best represent you when your matter comes before the court. Thanks for tuning in today, guys.
Thank you.